Social Security Administration is a huge and very complicated bureaucracy. If you were denied by the Social Security Administration for your disability benefits, I want you to know that you have an absolute right to appeal that decision. Just know that you must file that appeal within 60 days, typically 2 months of the date of that decision. And today we're going to go through the 4 most common levels of appeal in the appeal process. The first level of appeal is called the request for reconsideration, and that's where the evidence, the medical records, the lay testimony, everything you had at that first level where you were denied, all of that is gathered up, plus anything new that you may add to the evidence, and it goes right back to Disability Determination Services, the folks who made the first decision. But it's going to a different team. It's going to a different disability examiner and a different team of doctors. They get, for lack of a better word, a second bite at the apple. If you're not successful at the request for reconsideration level, then within 60 days, you're going to file an appeal, a request for hearing before an administrative law judge. The cast of characters at the hearing is going to be, of course, the judge, you, your attorney, a court reporter, and very typically there are expert witnesses, a medical doctor, a psychiatrist, or a job expert, a vocational expert witness. A hearing before an administrative law judge can be intimidating, so you want somebody by your side who can manage that process and help guide you through it. Those hearings typically last an hour or longer, and if you're not successful before the judge, you can then request review, file an appeal within 60 days with the Appeals Council. The Appeals Council is an appellate court, and they look down at what the trial judge did and said, and sort of side by side, they look at the judge's decision and they look at your assignments of error, the things that you said the judge got wrong. They determine then, do they agree with the judge? Do they uphold that denial? Or do they agree with you? If they agree with you, they can do one of 2 things. They can award you benefits, which is pretty rare, or they can remand it back for a new hearing as if that first hearing never happened. If the Appeals Council denies your claim, you can then file a lawsuit against the Commissioner of Social Security, and you go to U.S. District Court. That can be a lot of fun. It can also be really complicated. And then if you're not successful even at that level, there are 2 additional steps, and that would be going to Circuit Court or the U.S. Supreme Court. That's pretty rare. So primarily you're looking at the request for reconsideration, the request for a hearing with an administrative law judge, the Appeals Council level, and the U.S. District Court level. At James Scott Farron, we understand how confusing and complicated this process can be. We understand how frustrating it can be to receive a denial if you've tried it on your own. Just know that we're here. We have the know-how, we have the technology, we have the skills. I'm a board-certified specialist in Social Security disability law. This is something we can handle for you. This is something we can take off your plate so that you can focus on your health and your family. Give us a call. We're here to help.